The statute of limitations for a medical malpractice suit or a medical negligence claim is going to vary greatly case to case. Generally, if we're talking about the simplest of cases, I saw the doctor on this day and the error occurred on that given day, and that doctor is private, and I'm talking about a doctor who's going to be sued in New York State court. Generally speaking, it's 2.5 years from that day. Now, having said that, there are a number of exceptions to that and circumstances under which you may have more time. For example, if it isn't just day one, but I saw the doctor for a specific purpose. Let's say that I had a fracture. And so I saw that doctor on the day of the fracture, and I continued to see that doctor for 6 months until that doctor discharged me. That 2.5 years should, under those circumstances, be extended by an additional 6 months. That is called a continuity of care exception to the general rule. If I'm talking about pursuing a doctor who is involved in a federal facility, some clinics are federally funded. Certainly, if you talked about a federally funded hospital, it would apply there as well. You're suing under a statute known as the Federal Tort Claims Act. Under that circumstance, it would be a different cause of action that you're bringing and a different time period. Generally speaking, that claim has to be filed within 2 years, but when that 2 years starts to run is different than it is under state law. And I won't get into the details because it gets too complicated. It's suffice it to say, if you're in a federal facility, 2 years is the general rule, but again, when that 2 years starts to run and when your time period is up may vary greatly depending on the case. If you're in a local hospital that is municipal, meaning city-owned, county-owned, or if you're at a clinic that is city-owned or county-owned, different rules would apply again. The general rule for that sort of a facility is within 90 days of the events, you want to have filed what's known as a notice of claim. Now again, there will be some exceptions to that, but generally speaking, the caution is that you need to respond rather quickly in order to be within that time period. If you're outside of that time period, you can seek permission from the court to have that extended, but there are specific criteria that you're going to have to satisfy in order to get the court's permission to do that. The statute of limitations will also vary from court to court based on whether or not the patient is still living and therefore suing on their own behalf, or if the patient has died and now an estate is suing on behalf of the person who has died. So there are many different rules and they can be quite complicated, and so the best advice you can follow is, if you're concerned, talk to a lawyer, give that lawyer as much facts as you can about where it occurred, under what circumstances, who the medical provider or providers were, and make sure that the lawyer knows all that data so they can give you their best advice on when your time to sue will be gone. Because once the statute has passed definitively, that will end your right to bring the claim, no matter how meritorious the claim might have been.